morning. I'm Duarte Taída. I'm the managing partner of Abreu Advogados, and it is my pleasure to open the second edition of our Lisbon Law and Tech. This is an international digital event dedicated to the connection between law and technology. Today, our first session will discuss online courts and justice in times of pandemics. I have the pleasure to welcome and to thank our speakers, Richard Suskin, well-known author and president of the Society for Computers and Law in the UK, Maria dos Prazeres Beleza, Justice and Vice President of the Portuguese Supreme Court of Justice, as well as our partners, Pedro Barosa, criminal litigation lawyer, and Carmo Sousa Machado, chairman of the board of directors of Abreu Advogados and current vice president of the Portuguese Bar Association. One word about us. Abreu Advogados is a leading Portuguese full-service independent law firm acting in Portugal and in other Portuguese-speaking countries. Abreu Advogados does more than law. We are deeply committed with helping to build a sustainable future. In particular, we believe that it is crucial to share our knowledge about the laws with companies and the public and to help create awareness about our legal system and its mechanisms. For that purpose, we created in 2012 the Abreu Advogados Knowledge Institute that has become a cornerstone of the strategy of Abreu Advogados. Abreu Knowledge Institute, chaired by Luís Barreto Xavier, has been very active in this role of communication with clients and with the public. In particular, the Institute has been focusing for a while on digital culture in the world marked by digital transformation and innovation. Digital transformations that have now accelerated in the context of the pandemics. They have accelerated considerably. So in this context, it is in this context that we host this week, entire week of conferences, which are now starting. Welcome, hope you enjoy, and without further ado, I give the floor to Carmo Sousa Machado.
Thank you, Duarte. We have a great program and a fantastic group of speakers this morning. So I'm very honored to introduce today's keynote speaker, Professor Richard Suskin, a well-known visionary and pioneer in the topics of lawyering, justice, and technology. Evidence of this is that he wrote his doctoral thesis in Oxford on law and artificial intelligence in the 80s, decades ago. He is the author of, among other books, Tomorrow's Lawyers and Online Courts and the Future of Law. He has advised on many government inquiries, and since 1998, he has been IT advisor to the Lord Chief Justice of England and Wales. Richard is the president of the Society for Computers and Law, chair of the Online Dispute Resolution Advisory Group of the Civil Justice Council, and chair of the advisory board of the Oxford Internet Institute, where he is also a visiting professor. This is just a summary of his CV, of course. Professor Suskin, the floor is yours.
Thank you very much. Good morning, ladies and gentlemen. It is, in fact, a great honor to be here with you. I'm sorry I'm not joining you in person one day before long. I hope we can convene and continue this discussion looking one another genuinely face to the face. What I want to do today is answer 6 questions. I want to ask why we should modernize or change our courts at all. I then want to ask what mindset we should have in thinking about the future, how we should be regarding the future from a psychological, emotional point of view. I then want to ask what the technical options available to us are. Then I want to talk about the objections to the various ideas I present. I'll say a little bit about what the future might hold, and then advise what we should do now. So starting off with the question, why should we modernize? I think our current system around the world, which is based on physical hearings, is struggling to cope for 3 main reasons. The first, because of the awful virus, the reality is that many of our courts have closed. The second, I think, challenge for us is that because of COVID-19, huge backlogs are building up around the world. And thirdly, and we shouldn't forget this, we have the traditional access to justice problem. COVID has brought some new difficulties, but for many years we have had difficulties, which I can think is summarized best, I'm afraid, by the OECD, who say that only 46% of human beings in our world live under the protection of the law. And in some court systems like Brazil or India, the delays and the backlog are just enormous. 80 million cases in the courts of Brazil, 30 million in India. But even in the most advanced court systems, most civil disputes, for example, they cost too much, they take too long, the process is only understandable to lawyers, and increasingly the process is out of step in a digital society, and certainly for an internet generation. So we have reasons arising from COVID, as from access to justice more generally, to change fundamentally. So what mindset should we have in thinking about the future of our court system? The fundamental question I ask is this: is court a service or a place? Do we really need physically to come together on all occasions to sort our differences? Or might there be in a digital society different, new, better, quicker, easier ways of settling legal disputes? So technology is fundamental to my argument, but there are two different forms of technology. The first is automation, and the second is transformation. Automation is when you use technology to improve, to make more efficient, to streamline, to optimize our current ways of working. You place technology onto the ways of working of today to make it quicker, cheaper, or better. Now that's achieved a great deal over the last 60 years of legal technology and court technology. But I'm more excited by transformation, by which I mean the use of technology to help fundamentally change the nature of court service, to allow us to do things that previously weren't possible. Now, automation is something with which most people are quite familiar and comfortable. Transformation, the idea that our traditional ways of working might be replaced or disrupted, is more challenging. And I always go back to my favorite story in the world of management, which is a story about Black & Decker, who manufacture power tools. And apparently Black & Decker, when they recruit new executives, they take them on a course and they put up a slide. And the slide is of a photograph of a gleaming power drill. And they say to the new executives, "This is what we sell, isn't it?" And they all agree, of course, that's what we sell. We're Black & Decker. We're leading manufacturers of power tools. The trainers put up a new slide and say, "You're wrong, this is what we sell." And the new slide is a picture of a hole neatly drilled in a piece of wood. And they say, "That's what our customers want. And it's your job to find ever more creative and competitive ways of giving our customers what they want." Now, I want to say in relation to the courts that very often we are of power drill mentality. We think, what do we do today? That's the power drill. And how do we make it quicker or cheaper or better? We don't think enough about the outcome, the hole in the wall that our court users wish. By and large, around our world, our court system was designed by lawyers for lawyers and not so much for the end users. So I've said a little about the challenges we face. I've said something about how we should think about the future. I now want to talk about the technological options that have been open to us. And this, sadly, at a time of COVID, has become very clear. Because physical courts have shut, we've had to set up what I call remote courts. And if you have a look at the website I was involved in setting up, called remotecourts.org, you'll see news from more than 50 countries of how these different jurisdictions have been coping in setting up remote courts, non-physical courts, using technology. There's been three broad options, three broad categories of remote court: the audio court, the video court, and essentially the paper hearing. The audio hearing is the conduct of a legal dispute by the court using telephone conferencing. The video hearing is the conduct of a case, as one might expect, using video conferencing, like the technology we're using today. There's a third option, which I call the paper hearing, where there's no hearing at all, not a physical hearing, not a video hearing. The evidence and the arguments are submitted in electronic form, like an exchange of emails to the judge, a human judge. The parties engage in some kind of online exchange, but there's no hearing. There are the three options: audio hearing, video hearing, paper hearing. Now, overwhelmingly, the preferred option during the COVID period has been the video hearing. And the early evidence is that that has worked better than most people had feared. In fact, if you'd asked most lawyers and judges in January about the idea of video hearings, they would have said it won't work. But we've seen through quite a lot of adaptability and flexibility by judges and lawyers that we have managed to make video hearings work. They work fairly well, and judges and lawyers have adapted more quickly than we'd have expected. Minds have been opened to new ways of delivering court service. Minds have been changed. Many people who would have said, I won't use this technology, have now embraced that technology. We've also seen, of course, that COVID has accelerated this type of technology. But people say to me often, because I've written a book called Online Courts and the Future of Justice, which came out a year ago, that my future has arrived. Well, it's not my future, first of all, but also it hasn't actually arrived. I don't think home working is a full transformation in court service. I don't think dropping hearings into Zoom is a shift in paradigm, as people want to say. It may be reassuringly familiar, but that's because in Zoom, it's the same people, broadly the same rules, and the same problems subsist. It still costs a lot, takes too long, and it's not understandable to most people who are using the system. The truth is that COVID is like an experiment. It's allowing us to explore one form of new technology, largely the video hearing, and clearly we must gather data. We must know what's worked well so we can industrialize it, but we shouldn't think that this is the end game. COVID offers a springboard. It encourages us, I think, to consider new ways of delivering court service, but it's not the end of the road. And I am seeing the hint of what I call a new orthodoxy, a new conservatism, precisely because the COVID hearing is still fairly familiar to judges and lawyers. Many judges and lawyers want to say this is as far as technology can take us. But I want to say we're still at the foothills. We're just at the beginning of the change. And to explain this, I want to talk a little about what I call online courts, not remote courts, online courts in my book. I say there's two aspects to this. And I want to make it clear from the outset, I'm not saying these techniques will be used in all cases. My interest is access to justice. My interest is making our court system available, especially high volume, low value cases, to individual citizens who can't afford legal service and court service, and to small businesses who can't afford legal and court service. That's my main focus. I think there are lessons to be learned for the rest of the court system, but I'm not saying these techniques work in all cases. There are two aspects to what I'm suggesting, what I call online judges or online judging and the extended court. So the online judging is much as I described in relation to the paper hearing. The idea, I'll say again, is that there is no physical hearing. There is no oral evidence. The arguments and the evidence are submitted in electronic form by the parties to the judge. There is some kind of online discussion, like an exchange of emails, and the judge responds in the form of some kind of message. There is no hearing. There's a technical term for this, and it's called asynchronous. In communications technology, synchronous technology is when the people communicating have to be available at the same time. A phone call, a physical meeting, a video hearing. They can't happen unless the people are available at the same time. Asynchronous hearing or asynchronous communication is when people don't need to be available at the same time. Exchange of text message, exchange of emails. And the great convenience of asynchronous communication is precisely that people, for example, don't need to take a day off work to attend court for a small claim. The judge can do the work from his or her home. Many judges, in fact, in the future may not sit in traditional physical hearing rooms, which could help us increase the diversity of judges. So online judging is human judges, but making decisions on the papers alone. It's been going on in a limited way for many years. I think we can industrialize it to make the courts more available, particularly for lower value disputes. My second suggestion, though, the extended court, is more radical. My point here is that the state has traditionally thought that it has one function in providing an independent judiciary: the resolution of disputes, the delivery of binding, authoritative judgments backed by the coercive powers of the state. But if it's the case that our court and legal service is genuinely unaffordable, it's not enough simply to make judges available online. We need to offer more help. So I'm suggesting there should be a secondary function of the state. The state should provide tools to help people understand their rights and obligations, to understand the options and remedies available to them, to help them organize their evidence, to help them gather their arguments and present them in a coherent form. Now, this is a new function altogether, but there is no point in having judges and courts available if people require and can't afford lawyers to help them. Now, you should look at the Civil Resolution Tribunal in Canada, where this is working to very good effect. But they go further, as I do, and say that online, there should be opportunities before cases go to judges for parties to negotiate and perhaps to be facilitated, some form as ADR, but not as a private sector alternative, but as something that's baked into, that's part of the state provision. Now, there is another set of arguments which I also have made, that if the state can't afford to provide this secondary function, this can be delivered by what I call front ends, private sector providers. It may be the market, it may be charities, it could be educational bodies, but others could provide this front end. The problem there is that that service isn't backed by the coercive powers of the state. The outcomes aren't enforceable. And more than that, I worry that if we keep on finding non-state-based alternatives to dispute resolution, then this can affect the rule of law. We should have a court system that is on a daily basis affirming people's rights and obligations. We should have a court system that seems relevant and applicable, not only used, in my view, in the most difficult of cases. So why do I argue that online judging and extended courts are a good thing? Because in the first instance, this will offer a route to resolution where today many people have none at all. Most people today cannot afford legal and court service around our world. But even for people who represent themselves, self-represented litigants, who really struggle to organize their evidence and arguments, these tools, these extended court tools, will help offer them, I think, not just an easier journey, but an opportunity to make the best of their case. And finally, there are many people who today struggle to afford, but do pay lawyers and do pay courts in the traditional way, and they would benefit from this, I believe, lower cost system. I want to be clear, my aim is not to reduce the cost of court service. It's not to cut government costs. It's to increase access. It's to increase affordability. It may well be the overall cost is larger because the unit costs of particular cases may go down, but if many more cases go through the system, there may be an increase. I'm not having a discussion about the public policy of putting more money into justice. I think that's unarguable. Politicians disagree with me. I think our justice system needs greater investment. But what I am concerned about is for the individual litigant, we think of ways of making the system more accessible. And I'm not playing a pipe dream here. This is not science fiction. I can take you to, I've mentioned Canada, or indeed the reform program in England and Wales, or to Singapore, Australia, United States, and China. There are examples of elements of what I am discussing. I don't think there's any full-scale court system that's embraced all of this yet, but as one science fiction writer once said, the future has arrived, it's just not evenly distributed yet. So these ideas are in place, but just not across the court system. And let me say again to you that I'm not saying all court service should be conducted in this way. I see a future where court service is a blend of services. Sometimes we'll need traditional judges working in traditional courtrooms according to traditional process. Sometimes it will make more sense for that work to be done in a video hearing. But on other occasions, I think the online court is a way of offering access. But I do accept that people are nervous. The idea of judges without courtrooms and justice without lawyers, these are big challenges. And so naturally, there are many objections to this. Now, I address all of these. In fact, 1/4 of my 300-page book is devoted to addressing the likely objections, so that some people will say, for example, this is an economy class service you're suggesting. The rich people will have a first-class service in a physical courtroom, and people who are poor will only be allowed the online service. Well, I look at it a different way. I think if we can offer a service that's cheaper, quicker, more understandable, I think that sounds to me like the first-class service, and the old service for many people will look rather dated. It'll look like what we used to call in England a third-class train carriage rather than a first-class train carriage. People worry about open justice as well, and I do too, but my objective here is to increase open justice rather than to decrease it. And if there's been one experience of the video hearings, they through the COVID period have, for many people, the media included, have seemed to increase access. You could attend many court hearings in the one day without physically dropping in. Is it a fair trial though? And Europeans worry about this. They quote Article 6 and they say that a fair trial can only be held by and large where it's a public hearing. But I want to say that in the 2020s, we're revisiting our idea of what public means. In fact, when many people say they are making something public, they precisely mean they will make it available online. Will people be digitally excluded? We're also planning for the future here. And already, I think in Portugal and in England, 90% or so of people have access to the internet. That doesn't mean the other 10% are unimportant, but it does mean that they should not, in my view, stipulate the way that court service is provided. In England, we have something called assisted digital to help people who haven't got digital access to use the digital systems. Will it encourage litigiousness? Will people go to court more often? Well, I think that's a strange issue. If people have genuinely meritorious claims, if people really have a legal entitlement that can be enforced, it's a strange thing to say that the inefficiency of the court system is the way of keeping somehow litigation down. I want a society in which people can understand and readily enforce their entitlements. One important objection, however, is that what I'm anticipating is large-scale public sector technology projects. And most of these, according to research, 15% of these, only 15% of public sector technology projects deliver on time and in budget. And I think this is true, that public sector technology projects the world over often go rather badly, but that's a reason to do them well rather than not to do them at all. What I ask people to think about in these and other objections, I ask lawyers and judges often, is try not to look at the changes through the eyes of judges and lawyers, but through the eyes of court users. As I often say, patients don't want doctors, they want health. And we should think that court users often don't want courts and judges. They want a speedy resolution. They want an apology. They want vindication. But that doesn't mean we necessarily use the traditional ways. And so there's a second point, and that is that often people compare the system I'm proposing with the very best courts in their country. But I'm saying that's an unfair comparison. The comparison should be with nothing at all, which is what most people have. And so in the name of justice, critics often miss the opportunity to reduce injustice. What does the future hold then? And here I want to be very cautious, and I'm speaking long term, but I think as someone who has worked in artificial intelligence, I can be expected at least to address the issue. So I'm not saying, I'm not even recommending this, but I want to address the issue, can a computer replace a judge? And this is a question I've been trying to answer for 40 years. If the question is this, can a machine work like a judge? The answer to that is absolutely not. Machines do not have the complex neurophysiology, the complex brains of human judges. We're nowhere near that just now. Is the question, can artificial intelligence deliver decisions with reasons? Because but maybe not in the same way as a judge. That's a different question. But even in the world of AI and law, which is advancing, we're nowhere near having systems that can deliver conclusions and well-reasoned decisions. That's decades away in my view. But there is a different question. Can the state using technology provide binding decisions or determinations, not by human beings, but by using machines in entirely different ways? And here, just a thought to plant, and it is just a thought, is there are systems emerging now that can predict fairly accurately the outcomes of courts. It doesn't really matter how they do that just now. They do it in two broad ways. Let's not worry about that for a second. Just imagine that a system in a couple of years can predict the outcome of a dispute, say more accurately than a human lawyer, which is already possible in some areas. Then I want to suggest as a thought experiment the idea of prediction as a determination. And I want to take you back to Brazil, where you remember the backlog of cases is 80 million. Most of these cases will never be settled. But imagine this. Imagine if they developed systems so they could say to parties, we have a system that holds all the past cases and information about all the past cases in your category of dispute. This system can predict the outcome of court decisions to a very high degree. Would you accept that decision, or that prediction rather, of the machine, if it's perhaps to a degree of confidence of 97% or higher? Would you accept that as a binding determination of the court system that would be enforceable as though it had been delivered by a human being? Now, I accept it's an entirely different way of coming up with a binding determination, but remember again, we're not comparing it to the human judge, we're comparing it to the 80 million people, most of whom will never have a binding decision. And if after all, the system simply reflects the past decisions of the court, it's an interesting proposition. That's the only prospect I see for, as it were, machines taking on some of the work of judges. Now, the techniques that will be used there will be based on machine learning. And of course, there's a worry about the bias that might be in the past data. And of course, there's a worry that these systems can't generally offer explanations of their lines of reasoning. But these are issues we can discuss. I just want to put this out as a thought experiment. My practical point is that today we can put human judges online and extend the function of the courts in a way that will deliver access to justice. For sake of completeness, I thought I should mention AI. So what should we do now in conclusion? I've said before, I think what we have here is like through COVID, is like a massive unscheduled pilot or experiment or consultation exercise in the use of video hearings. And we do need to assess what's gone well and gather data on the technical problems, technical successes, the business implications, the costs, the cultural implications, and its impact on justice. But we should be able to gather that data. In fact, it's a unique opportunity. People used to say to me, how can you recommend technology use of the justice system? There's no evidence. And I used to say, well, there's no evidence from the future. There's never evidence of the future. But now actually we do have evidence. And for the first time, at least some of our policy making about the future can be evidence-based. I want you to think about this too, though. A decision not to change is also a policy decision. And I often ask, on what data or evidence is the decision not to change based on? Because in most court systems around the world, we have very little data about the performance of our courts and about the satisfaction of users, for example. But in conclusion, I would want to say to you, in Portugal as elsewhere, I think we have to divide our thinking about the future of courts into three phases. In the short term, what we need to do is stabilize and improve the temporary systems that are currently being used so that we can minimize the disruption over the next 6 months or so through the remainder of the crisis. In the medium term, we have to, I think, take what's gone well during COVID and make sure that we capitalize on that. And we use that in helping us cope with the backlog we've created. And also we feed that into any reform programs that we already had in place before COVID. But I think in the future, looking long-term as our third option, we need to think more radically if we're genuinely going to increase access to justice. And that doesn't mean automating our current people and processes. It doesn't mean offering remote video access to our physical spaces. I think it requires us to think more fundamentally. I think it requires us to recognize that court need not always be a place, but is always a service. And it needs us to think about how to use technology, not simply to perpetuate our past working practices, but to allow us to deliver a court service that previously wasn't possible. Thank you very much for listening. I very much look forward to feedback and discussion.
Thank you very much. We will have a time for discussion later, so I'm pretty sure that we will have a lot of queries and things to discuss. I would like now to ask Justice Maria dos Prazeres Beleza to intervene. She is Vice President of the Portuguese Supreme Court of Justice, the first woman elected to this position, and was a judge at the Constitutional Court. She's also a professor of civil litigation at Católica Law School. The floor is yours.
Thank you, Dra. Carmo Sousa Machado. And thank you, Mr. Suskin, Professor Suskin. I apologize because it was a brilliant presentation of your ideas. It's a privilege for me to be here. Thank you, both of you. Well, I will try to say, a brief comment of what we heard. As Professor Suskin said, COVID-19 has brought major difficulties and challenges to justice all over the world, and Portugal is no exception. I mean, those challenges that you referred to, Professor Suskin, were to maintain a sufficient level of service, to prevent a major accumulation of non-decided cases, and the third challenge is to solve the access to justice problem, which really is a problem. The major problem are the oral hearings in a courtroom, mainly when evidence is being heard, and other proceedings that require the physical presence of parties or lawyers. Virtual courtrooms have been created in the first instance as well as in the upper courts, I mean the Courts of Appeal and Supreme Court of Justice. And sometimes there are virtual hearings. Sometimes the hearings are adjourned. Sometimes there are physical hearings in the courtrooms. Well, it depends on the circumstances, the possibilities, or the subjects. For instance, parental responsibility. Some court use other ways of communicating, for instance, by phone, by mail. Well, it depends on the circumstances. The appeals are mostly decided on the basis of written arguments, and the court sessions of the Courts of Appeal and of the Supreme Court judges have been video conference sessions. It's new, it's a new thing. I'm trying to speak more quiet. In civil disputes, when lawyers represent the parties, there is an electronic platform to submit their initial statements and the final briefs, and also for the judges to deliver their decisions. Under the Portuguese law, there are no judgments by juries in civil matters, so I won't speak about the problem of the juries. So COVID-19 forced courts to develop the automation, as you said, but they maintain their working methods, adjusting to circumstances, namely when working in remote hearings. Well, now I would like to talk a little bit about the Supreme Court. The Supreme Court has been working this way. The major change are the video conference sessions. The online platform was already functioning before the crisis for the first instance and for the Courts of Appeal. In the Supreme Court of Justice, judges use it direct or indirectly, with the help of the court clerks, but most of them, they use it. The Supreme Court has 4 civil chambers, 2 criminal chambers, and 1 labor chamber. There are major cases that require the intervention of all the civil chambers. Those sessions have been adjourned to allow a physical session in the court. I agree with Professor Suskin. As far as the Supreme Court is concerned, the crisis accelerated remote court sessions and the work with the platform. What I would like to say is that it is true for the Portuguese courts that the COVID-19 crisis accelerated and in some way changed the way of working, mainly for the upper courts. Well, I also agree with Professor Suskin that there is a very real and a very serious problem of access to justice, mainly with small value civil claims. Access to justice and effective judicial protection are granted by our Constitution, but it's difficult to materialize these guarantees. As Professor Susskind also says, going to court costs too much, the courts are too slow, and legal language is inaccessible to lay people. It may be a serious problem for the claimant, but also for the defendant, mainly when the claimant is a mass provider, a bank, an insurance company, the tax authority, the telecommunication companies, well, because they always go to court well represented by lawyers, and they have no problem in litigation. But lay people who are involved in small claims or in small civil disputes, they will probably need legal advice for deciding to go to court, for preparing his or her defense, for the whole procedure. Denying the access of justice is not only a personal problem, it's a denial of a fundamental right and a serious deficiency of the whole legal system. So, how to solve the problem? Well, in part, I agree with Professor Suskin, in part, I don't. The small civil disputes, I mean, the low value civil disputes are often repetitive. Debt collection, damages claims, traffic accidents, for instance. And that small claims can be correctly judged according to a simplified procedure and quickly decided by small claims courts and online. I think that legal aid, for instance, might solve a digital exclusion problem. You talk in your book about the digital exclusion problem. It's a real problem, but it can be solved. But I'm sorry. But in my point of view, like all civil disputes, there must have a public hearing in a courtroom. I know you disagree, and that you think we should go back to courtroom here. We shouldn't go back to court hearings. Why do I think that a public hearing in a courtroom is necessary? It's mainly because, first of all, I think that evidence and oral arguments must take place in a courtroom hearing. I'm thinking of witness statements or expert proof. According to Portuguese law, judges play an active role in the evidence, but lawyers play the main role, of course. Secondly, court hearings are public according to the Constitution and the law. It's not only a guarantee for the parties, but also for the public trust in courts and in the rule of law. Offering public access to the meetings is not enough, I think. Third, ritualism plays an important role in court hearings. Maybe I'm old-fashioned, but all sovereign bodies have their own ritualism. And now I would like to say something about the extended courts. As far as the extended courts are concerned, I really think that guidance on the entitlement of the litigants, as neutral as it may be, or it must be, involves a danger of breaching the principle of the separation of powers and of the public trust in the impartiality of courts. I know that judges may not be involved, but it's a court service. The way you explain it, I know. You said that judges may not be involved. It's a separate service, but it's a court service. And if it is a service provided by the state, I ask, who is liable if the wrong information or a bad advice is given? Well, two last brief comments. First, can machine replace a judge? First of all, I hope I won't be replaced by a machine. Well, I would like not to be replaced by a machine, but as Professor Suskin wrote in his book, case law is difficult to translate into code because, and I quote, to identify a ratio decidendi of a case, you need to make a concise interpretation rather than a literal translation of the law. I was quoting. But in civil law systems, all legal texts must be interpreted following the statutory interpretation rules. Plain meaning is just the basis of the legal interpretation. You need to consider the legislative history, the legal system, the current time, the broad or stick meaning of the words. What I would like to say is that both systems are difficult to transform into code. Well, in both systems, the data involve a previous interpretation work that limits the data. Well, I don't think that machine can replace judges. I don't think that machine should decide cases. Well, unless the litigants accept it, but if the litigants accept it, it's not the state that decides that the machines can replace judges and provide binding decisions. Finally, I think I have time. Finally, I would like to answer to your question that court is a service or a place. In digital society, shall it be considered a service online? Shall we transform the way courts works towards online courts in the asynchronous way Professor Suskin has referred? I don't know, I can't pronounce that word. Well, I think that justice should not be compared to online services. I also think that that while it's not possible to come back to courtroom hearings, courts should continue to work the way they do now, with courtroom hearings, if possible, with remote hearings when necessary. But justice is much more than a service, and it should be delivered in courtrooms with the necessary intervention of lawyers when the representation of the parties is mandatory or not. Their intervention, I mean the lawyer's intervention, presenting evidence is really absolutely necessary for justice to be given. That's what I think about what Professor Susskind said. I apologize to disagree in several points, but it's my point of view. Thank you.
Thank you. So it is now the time to ask Pedro Barosa to join us. Pedro is a criminal litigation lawyer and a professional partner at Abreu Advogados. He has extensive experience in criminal defense, especially in cases related with economic, financial, and tax crimes, white-collar crimes, I would say. So, Pedro, please, the floor is yours.
Thank you very much, Carmo. And I would like to thank also to Luís Barreto Xavier for making this all possible. It's an honor, it's a privilege to be here with Professor Richard Susskind, who is a pioneer and a leader in this field, and also with Justice Maria de Prazeres Beleza, who I was lucky to have as my teacher in Católica University School of Lisbon. I took the chance of reading Mr. Richard Suskind's book, and the first remark I would like to make is that I was glad to know and to notice that the final draft of the book was submitted while Professor was on holidays here in Portugal. Correct me, please, if I'm wrong. I strongly believe that Professor Suskin is a visionary. Not only because of his struggle, his fight, and his aim of improving the access of justice, but also because when he wrote this book, when he thought about online courts, he was far from knowing that the COVID would appear. And of course, for us, from my point of view, it's easy to understand the book while reading it nowadays, but truth is, when Professor Richard Susskind wrote it, this was not happening. I must confess that when I started reading the book, I was pretty skeptic. The most amazing thing that, like you addressed half an hour ago, the most cleverest thing that Professor Richard Susskind made in his book was to anticipate all the objections that could be made or arise from the readers, from people, but especially from judges and lawyers. And you respond to each one of them. And the thing is, I globally agree with your ideas, and especially with the main principle that you thought about, the fact that the justice is not a place but a service. And responding to Justice Maria de Prazeres Beleza and addressed this topic, and anticipating your response, I would imagine that you only thought about that idea because justice as we see nowadays is not working as a place. I would also anticipate that if you see the courtrooms running well and justice working, you would not think about the question, is justice a place or a service? But that leads me to another topic. For instance, like Justice Maria de Prazeres Beleza was saying, here in Portugal, and from my perspective, before COVID, things were not running right. And we have, and I love my country, and I love the judicial system, the Portuguese judicial system, and also the civil the civil system. However, judges were not receptive to virtual hearings, video conference, remote hearings, and in January, judges would not anticipate that this could happen, of course. And the thing is, since we had COVID, of course, courts had to implement virtual hearings. And from my point of view, I must say that I think that things are running pretty well, and I must also state that after all this strange period is over, I believe we are not coming back. One other thing that you address in your book, and I read your book in one weekend, I must tell you, it was very easy to read and to understand. And one of the things that you say is that courtrooms are inadequate, old, and out of place. And I totally agree with you. The language is totally unintelligible. The formalities are, if I may say, a little bit ridiculous. Also, I think I pay attention to your book, but you didn't address one other example. For instance, you didn't tell about the robe of the judges or the toga from the lawyers, or even more ridiculous, if I may say, the wigs in some countries. Well, this explains how old is justice. Moreover, from my point of view, the problem starts at the universities, in law schools. Law teachers keep teaching law to students like we were in 19th century. And that's, for me, that is one of the major problems. So your book, in my point of view, raises a lot of concerns and questions and presents solutions. One of the main suggestions that you make is the end of oral advocacy. Professor Richard Suskin, I may say that I was not happy when I read it. I enjoy being in a court. I like to be inside the courtroom. I like to feel the energy. I like to look into the judge's eyes. I like to see my opponent, to fight with him. I think that the argument, it's very important. Of course, the evidence too, but the argument, the oral argument, it's very important. I also think that it's fundamental, the empathic aspect, the emotional component of the court. So I wasn't happy with your idea. However, you also anticipated this in your book. And you told me, I was the one reading, I was reading alone, you told me that a very interesting expression is, courtrooms are not made to give lawyers, what was the expression? To give lawyers meaning to their lives. And that's exactly the point. I was looking to the end of oral advocacy from my selfish point of view, from my happiness as a lawyer and as a litigant. So I was relieved when I realized that, fortunately, you thought that criminal cases were beyond the scope of your book and of online courts. Although I felt that you would like to extend the online courts to criminal cases as well, but for minor offenses. You were pretty clear when you stated that. You spoke something about medicine in your brilliant intervention. I think medicine is like the justice. I think in order to patients to be treated, they have to go to the hospital. Then they can have medicine, of course, at home, but they have to go to the hospital to be treated. And moreover, they need to feel that they are being treated. Your book also addresses this aspect, and you illustrate this thought with the example of therapy. And you were pretty clear when you told that before people try to make therapy remotely or through text message, they don't like it. But as soon as they do it, they start preferring it. But regarding therapy, of course. But my disagreement regarding that example is, even if you have therapy remotely or through the phone or through internet or through virtual hearing, truth is, you still feel the feedback, the immediate feedback from the psychotherapist or the doctor, if we are talking about psychology or psychiatric. So in this model, that doesn't happen. You don't have immediate feedback from the other side, namely the judge. And that leads me to two small and modest observations. First of all, I think in your model, in your brilliant idea, I think it lacks some sort of emotion. And what I'm trying to say with this, I think justice is not only the outcome, but also the way over it. And I think people need to feel that they are heard. That's most people, of course. I'm not talking about all cases, but a lot of people need that feels to be heard. And another important aspect from my point of view is, more practical maybe, is lawyers love to write. And Justice Maria de Prazeres Beleza would agree on me on this. We write too much. Maybe we could write most of times with half of time and with half of the space of the documents and pages. And with the end of oral advocacy, I believe it would be possible, or what will happen is lawyers will be encouraged to write more and to overload justice. So we have two options. In your model, I don't think it's pretty clear. I will ask you to clarify me, please, about that. But on one hand, you can submit online pieces or pleadings without any lawyer, without the assistance of any lawyer. That has a problem for me, because there are people who cannot present argument regarding the facts or the law effectively. And orally, it can be easier. On the other hand, if you have lawyers assisting the clients, maybe that it will happen. The example that I thought about before, lawyers will write too much because they don't have a chance to do oral argument. Either way, in your book, you quote Steve Jobs. And you were right by quoting Steve Jobs, because Steve Jobs was right when he stated that correct me if I'm wrong, please, give people what they want before they know they want. That makes total sense, especially for Apple. Before cell phones, we didn't need cell phones. Now we cannot live without them. So it's true. And I think that sooner or later, and at the end of the day, online courts, fortunately or unfortunately, will happen. What leads me to the final remark to your granddaughter, Rose, to whom you dedicated your book. You said in your book that when she becomes 21, she will ask you why did her grandfather lose so much time and energy writing so obvious things. Well, my suggestion is to you, Professor Richard Suskin, is to respond to her, saying that because it was because people like me that turned this possible. Thank you.
Thank you.
Thank you very much, Pedro. I would give the floor back to you, Professor Suskin, because I believe you would like to respond or make some statements about what was said here before.
Well, thank you very much. Thank you, both of you. It means a great deal to me to have two such expert and experienced people making observations about my work. As I keep on saying, I'm trying not to end a conversation. I'm trying to start a conversation here. And so there's much more work to be done. I just wanted a couple of responses to the judge, if I may. The first is the idea of public hearings. And I just wonder whether or not our conception of what is public is going to change. I hinted at this, but we talk of Rosa, my granddaughter, to whom the book's dedicated. I don't think, but I don't know, but I don't think when she's 21, she will regard a public hearing in a courtroom as a more public activity than some kind of online engagement. Indeed, we run the risk of thinking that what we call a public hearing, consistent with a European convention of over 70 years ago, before the web was invented, before the internet was invented, of thinking that public hearing with which we're comfortable is something with which other people are comfortable and regard as quintessentially public. I don't accept that. I said earlier, I think we now have a use of language when we say we go public or we make something public, that precisely means we'll make available that in the internet. So I think I'm happy to say that a lot of work that'll be done and court service will be delivered via technology will be every bit as public, not according to our old conceptions of public. I do worry, though, also that, and I know it was not the role of the judge to come up with an alternative suggestion, but I'm putting up there a suggestion of something that I think will greatly increase access. And what lawyers and judges generally do is, in the nicest possible way, shoot me down, but they don't say, here's the alternative way of doing this. I've got a better idea. Lots of judges and lawyers say, throw more money at it. It's all about public legal funding. But if I'm right, and that lawyers and courts are disproportionately expensive, time-consuming, combative, and so forth, throwing money at that doesn't sort that problem. That just perpetuates the difficulties we have. And so if the system is disproportionate and unaffordable, it's disproportionate and unaffordable for reasons we need to address, not by simply putting some sticking plasters on, which would be more and more public funding. The judge also mentioned ritualism. And in a way, what I'm saying is I think we need a new ritualism. But I am fundamentally saying that I don't think court users want robes or crests or wigs or gowns or majesty. They want their problems resolved authoritatively in a way that's affordable, in a way that's relevant. And we need a new ritualism to surround that. I've got a whole thesis of that in my book. I call it outcome thinking. I think we're wrong to think that it's the same point. Patients don't want doctors, they want health. People don't want courts, they want outcomes. And if we can think of new ways of delivering authoritative binding solutions that are more relevant, that retain a solemnity of occasion, I don't think we need, as the second intervention said, I don't think we need a lot of the trappings. I think we need ritualism, but I think we need a new ritualism. We need a new way of conducting a solemn online process. The separation of powers point about the extended courts is one I deal with extensively in my book. And it may well be two options. One, it may well be that that service can't be part of the court service, that it needs to be an additional state service. Or secondly, and in my more recent article online at Harvard Law School, I talk about the idea of front ends. I think I might have mentioned it in my talk, where we might have a different way of providing these services. But I'm absolutely clear that there is no point in offering a more accessible, affordable court service if you have to pay lawyers and people can't afford lawyers. It's you know that old phrase about the Ritz, like the Ritz is open to every, which is a wonderful hotel. The Ritz is open to every person, rich and poor. Of course it's not. Of course you can walk through the door, you can't afford it. The reality is just now that most people are walking while a very few benefit from a Rolls-Royce service. So if this relates to my point, my fundamental point in a way, the question is not, can machines or online courts replace judges or conventional courts? That's not the question. The question is, can machines and online courts offer access to justice where today our judges and courts cannot? So my ambition is not actually to replace our current courts and judges and work. It's greatly to increase access either to those who don't come near to the court system because they can't afford it, or to those who represent themselves and do so very badly because they don't have the knowledge or insight. So I say again, the question isn't, can online courts replace traditional courts? It's, can online courts increase access to justice in a world where we have no alternative? And if someone can come up with an alternative, I'd love to hear it. But in all the critiques I receive, it's all, and this is not criticism today because you were asked to comment, but in all the written reviews of my book and so forth, no one's got an alternative narrative. If there's an alternative narrative, let's look at them. Let's look at online courts versus something else. But just now we've got online courts versus nothing. And that's my main point. Let me, the second set of observations were actually in many ways more supportive, but you came up with a couple of challenges which I wanted to meet. I think it's true, incidentally, I did explicitly say that online courts were, or online criminal courts were beyond the scope of the book. That doesn't mean they're beyond the scope of my ambition. They just meant they're beyond the scope of the book. But you talked about justice being a feeling, and I hope I do address this, because I actually still think it's an outcome as it happens. But I identify, and this is important, I think, for the judge's observations as well, I identify 7 different conceptions of justice that must be met. And I say this because it's quite interesting that people talk about justice both to attack and defend my book. They say of my book, online courts would defeat justice, and some people will say it would increase justice. So to give an example, there's a notion of distributive justice, which is the idea that a good is made widely available. And just now we have a very distributively unjust system. The decisions our courts do make are substantively just, which is another category, but there aren't enough of them. And the inaccess to justice problem is a piece of, in my view, intolerable distributive injustice. So we need to balance up, on the one hand, in making the system more distributively just, what sacrifices are we prepared to make? Now, I'm not prepared to sacrifice procedural justice, which is about fairness of process. There's all sorts of different terms, but I think it is also, it's not just about the process being fair on paper. It's that people, when they come out the other end, feel they have been justly treated. And that's part of the outcome for me. And there are many ways, my point is, that you can deliver that feeling of fair treatment. And if you look at, for example, the research that's been done on the work of the Civil Resolution Tribunal, where they've interviewed huge numbers of people who've been through that system, they do seem to feel a sense of justice and good treatment. And that just shows that there are other ways that one can deliver that sense of justice beyond the current ways we seek to deliver it. This is why I think it is, I think what we call procedural justice, the fair trial, the due process, the treating like cases alike and so forth, they're all in a way only relevant to the extent that people at the other end of the process feel well treated. And what I'm saying to you is we should open our minds to different ways in which we will feel well treated. It's not at all obvious to me that all, and I analyze this as I used to teach legal philosophy. I analyze this as a legal philosopher in my book, but it's not at all obvious to me that the younger generation will feel the same about a process, in characterizing a process as fair. A lot of the processes that exist in the justice system today that are meant to uphold the very fairnesses you're talking about, they look obscure, they look arcane, they look outdated, and that doesn't build confidence in a fair system. It looks like a system designed by lawyers for lawyers, which is precisely what it is. So my second argument is about how can people make their own arguments online if they haven't got lawyers to help them? And that's part of the extended court function. Again, I deal with this in the book, and we need to do more work on this. But we can, on the one hand, not ask people to lay out their arguments, but to elicit their arguments by question and answer. My PhD was in that precise form of legal dialogue. It's a very different legal dialogue. It's a dialogue that in a way is led by an expert, but it's led by an expert system. They'll ask a series of questions to pinpoint the person's problems, and then we will be able to recast these responses as an argument for the judge. So there are many, or there are standard argument flows that we can put in place, because to be honest, so many of the low value, high volume cases do not raise complex questions of law. They're standard set pieces, and we can do more work with automated document assembly, with diagnostic expert systems, with standard flows. I believe we're not there yet, but I'm not writing about today. I'm writing about the rest of the decade and beyond. I think there are techniques that can allow a person who is comfortable with language to be able to formulate their own arguments. And again, if you look at Civil Resolution Tribunal, that's designed, and remember, with a high degree of user satisfaction for people of a reading age of 10. So it's being done. It's just, as I say, it's fairly rare at this stage. But in all of this, I go back to my plea. I'm not saying this is better than the best judge in the best physical courtroom. I'm not saying we should never go back to the physical courtroom for any cases. I'm saying that for most people in our world, they can't afford lawyers, they can't afford judges, and they have claims that they cannot actually pursue. And it seems to me that as lawyers, we should be ashamed of this. We went to law school surely to help people understand and enforce their entitlements. And we have a system in place just now that for most people helps with neither. And I believe that the answer is not to simply streamline our old ways of working. It's not to throw money at our old ways of working. We need something transformative. And I really am saying that mine is the only answer, but I want to put it out there and say, I've got the guts to say, here's a different way of doing it. If critics have alternatives, that'd be more powerful than shooting down what I've got to say in flames. I'm not saying that to extremely, I thought, articulate and thank you, very respectful accounts today. But you would not believe the amount of trolling I get on social media, which by lawyers, when after all I'm trying to do is increase access to justice. People see it as an attack on lawyers. It really isn't. It's attacking our justice system, which is not delivering. That's all I wanted to say by way of response. Thank you so much, folks, for taking the time to read my book and work so carefully. That's really appreciated.
Thank you. I don't know if you, Justice Maria dos Prazeres Beleza, or you, Pedro, if you want to add something else.
Okay.
Yes, if I may.
Of course.
Well, first of all, I read your book with most interest. It's a real challenging book. It makes you think of the justice we have now and the justice we should have. I agree with you with many things, and mainly with the problem with the excess of justice. I would like to say something to what you said in my answer. Well, I do believe that my children, when they will be 21, they will think that public is not what I think it's public when we think about justice. Public hearings do have a meaning in the state of law, in the trust that people have in judicial system, and in the acceptance of the court decisions, even if they lose their cases. Well, when I think that when I'm talking about public hearings, this is what I wanted to say, is that it's important for the trust, the public trust in justice, and for the rule of law, the trust in the rule of law, that in our way that we today think public is public, that hearings are public. Second, you said it's difficult to offer another solution. It's easier to disagree with one solution, but it's more difficult to present another solution, of course. Of course, what I said is that about small claims, about small or low value civil cases. And what I said is that generally they may be judged, or they may be filed to court and be appreciated or decided in a simple with the simple procedural rules. and be quickly. Well, it's not a great solution, but we have in Portugal small claim courts. I mean, Julgados de Paz, for instance, that's peace, justice of the peace, more or less, where people can go for small claims, where they don't need to have a lawyer to represent them, where there is a mediation service, and where the judges are, they try to solve the cases by conciliation and not by binding decisions. So we have this in Portugal. I don't know if it's a solution, but it's one solution. In the third place, oh, I'm sorry, I am not. I have no COVID, but my voice is strange. The ritualism said, well,
You can't catch Zoom. You can't catch COVID over Zoom, thankfully.
No, that's good.
well, but anyway, well, I said that ritualism is important. Well, ritualism is important when it has a meaning, when the government, the parliament, all they have rituals. And I think that it's important for, once again, for trust, for public trust in the administration of justice. It has been, it has been like that in several centuries. Maybe we'll change the way of thinking, but now I think that it's important. Finally, I was talking about extended courts in the meaning of your book. When I said, I hope I won't be replaced by a machine, I was not talking seriously. Well, but we never know. But what I was talking about is what it is difficult to transform law into data that you, and it's difficult to give a machine a solution for cases which has certainty. I mean, you said, well, if litigants accept the decision of the machine, well, there will be no problem. But for me, the problem is that can the state consider machine decision as binding and enforceable, even if the parties don't have accepted that the machine would solve their case? That's my problem. I'm sorry. And as Pedro Barosa, I apologize for teaching civil procedure in the 19th way. Well, but that I was not able to teach other way. I'm sorry.
Thank you very much.
Okay, so I believe Pedro, you would like to add something?
Yes, I will. I will, if I may. Justice Maria dos Prazeres Beleza. I'm a criminal lawyer, not because I ran out of the civil procedure because of you. Please bear that in mind, okay? Okay. Let me just comment before Professor Richard Susskind. I believe, well, it's very interesting this conference and the fact that one of the persons who is disagreeing with some of your ideas is a judge. And why is interesting? It's because your proposal, your suggestion is not only to allow the access to justice, but also to not avoid the overloading of the justice. And we have here a judge of the Supreme Court of Lisbon disagreeing with you even regarding the civil claims of low value. And this is precisely where I agree with you, is regarding this small case. So I believe Justice Maria de Prazeres Beleza is or has more authority than myself when she disagrees in this concrete aspect.
Okay. I don't know if you would like to add something. We need to wrap up.
Were you asking me if I'd like to add something?
Yes, yes.
I'd always like to add something. I never turned down an opportunity to add something. No, I wanted to thank you all for your comments. And this is precisely the kind of open, good-natured, productive conversation we need to be having. But just I urge you in Portugal, as I'm trying to do in England and Wales, is to have more and more of this discussion, to identify what's practical, what's probable, what's not a runner, where we might need to make compromises, to recognize the distinction between being a lawyer or a judge on the one hand and a policymaker on the other, where some practical decisions need to be made. But I've greatly enjoyed the opportunity to have this discussion. It is true, as was said, that my book was finished in Portugal because I love playing golf in Portugal. But it was the first country beyond England I ever visited. I've got very happy memories. I come to you regularly and hope we can get a chance to speak again, actually in person before long. Because although virtual stuff is good, it's nice to meet people and to share drinks and meals and conversation. So thank you very much for involving me.
Thank you so much. So since we are already running out of time, I have to thank Professor Suskin, Justice Maria de Prazeres Beleza, and of course my colleague Pedro Barosa for sharing your views with us. And to close this session, of course, a word as well to Luís Barreto Xavier to make this event possible. I hope the event has provided you with new insights on this important topic, and that it had opened your minds as it opened mine, being a litigating as well. I would like to invite you to join us for the upcoming Lisbon Law and Tech sessions till the 26th of November, starting as this one at 11 a.m. The topics to be discussed cover legal design, global trends, and regulation of artificial intelligence, as well as legal engineering. Thank you for your time and stay well. Thank you.